Associate of Banwan Ighodalo, and who will be anchoring this event. So Chinasa, would you like me to stop sharing so you can share from your end? Is that okay?
So you may continue sharing. I'll just
all right. Thank you very much. So this is to officially welcome everyone to today's program. So I'm going to hand over now to Chinasa to continue with the agenda for today. Over to you, Chinasa.
Thank you very much. Good morning, everybody, and welcome to today's event. It's a pleasure to have you here and to be part of this celebration today. So every year on the 25th, 26th of April, we celebrate the World Intellectual Property Day, which is basically a date to celebrate.
Sorry, I think your speaker, can you speak louder into the mic?
Okay. Is this better?
Yes, it is.
Okay. I was just saying that the World Intellectual Property Day is celebrated every year on the 26th of April. Celebrate creations of the human intellect, developments in technology, advancements in new things, innovation, and so on. This year's World IP Day aims to focus on the critical role that small and medium enterprises play in the economy and how they can use intellectual property rights to build stronger, more competitive, and resilient businesses. The theme of this year's celebration is IP and SMEs, taking your ideas to the market. As we all know, SMEs, that is small and medium enterprises, are the backbone of national economies. They deliver the goods and services we need every day. They hatch breakthrough innovations and inspiring creations, and they create jobs. Some become the world-leading businesses of tomorrow. In Nigeria, we have over 41 million micro, small, and medium enterprises that are responsible for almost 50% of the country's gross domestic product and 75% of the Nigerian labor force. So we have a nice array of speakers who will be discussing the issues relating to IP and SMEs and how you can take our ideas to the market. And we'll be starting with Mr. Olumide Oshundolire, who is a partner in Banwan Ighodalo. But we have other speakers as well, some of whom I'm sure you have already seen in the audience. We have the Director General of NOTAP, Dr. Dan Azumi Mohammed Ibrahim. We have the Deputy Director, Legal, Nigerian Copyright Commission, Ms. Linda Alfius. We have Enel Bongusen, the Principal Assistant Registrar from the Patents and Designs Registry. And then we also have Odunoluwa Longin, the co-founder of Do It Yourself Law and the Longe Practice. So quickly, I'm going to introduce Mr. Olumide Oshundolire to set the tone for today's event. Olumide Oshundolire is a proactive and versatile lawyer. He has spent the last decade being exposed to various areas of legal practice, including but not limited to commercial law, intellectual property, and ICT law, with focus on trademarks, copyright, and negotiation of technology transfer agreements. His commitment to exceeding clients' expectations and the assurance of success in any transaction with which he's identified places him above the ordinary lawyer. Like I already mentioned earlier, Olumide is a partner in the Intellectual Property and Technology Practice Group of Banwan Ighodalo, leading full-service commercial law firm in Nigeria. He has advised on various aspects of technology law, from technology acquisition to setting up of e-commerce platforms, drafting regulations, procurement of operating licensing, and so on. He'll be speaking to us this morning on understanding the role of IP in business growth and success. Mr. Olumide Oshundolire, welcome to the program.
Thank you, Chinasa. Hello, everyone. If you just give me a few minutes so that I can present, at least share my presentation, and then we can start. Okay, good morning, everyone. I hope you can hear me. I'll quickly just jump into my presentation and start straight away. When we talk about intellectual property, what exactly do we mean? We're speaking about the intangible and the non-physical assets, which are the product of human intelligence and creation, essentially the outputs of your mind. And example of this include literary and artistic works, inventions, images, sound recordings, architectural work, computer program. You will notice that I did not put ideas here. And that's essentially because it's until it is expressed, ideas are not really recognized by the law as something to protect. And usually, so it is when your idea is expressed in a format that intellectual property law then comes in to protect it. And essentially what IP law does is to protect the interest of creators and other producers of intellectual goods and services by granting them time-bound monopolies over the control of the production of their intellectual efforts. So essentially what it means is that you are given a monopolistic right to control what you have produced. Essentially, intellectual property is another form of property. The same way you have land, you have car, you have houses, you have dress. What the law has done is to create certain property rights over the product of your mind and to give you monopoly over the use of that creation. And this could be quite valuable for businesses. And the importance of IP to companies really lies in the fact that, number one, your IP gives you that competitive edge. It gives you that unique selling point that sets you apart from your competition. When you approach the market, what you are saying is that this is what we offer you. There is the promise that we have made to you. For instance, if you read the story of Steve Jobs and Apple, we find that Steve Jobs said that when you hold an Apple product, you are holding something that is sophisticated and stylish. And that is the promise they made to the market. And when you look through all their products, that is what you see. So that's what IP do. IP tells the world who you are. It's a form of identity. And it sets you apart from every other person. In this age, you understand that new and original knowledge and creative expression of ideas are the driving force of successful businesses. That is what's making businesses excel nowadays. And once you can invest in those creative expressions, you need to protect them. You need to treat them as what they are, a valuable asset of the company. And when you are able to strategically manage your IP assets, what it becomes is your IP assets become valuable source of revenue to you. And this is seen in all the companies of the world, the successful companies. When you study their structure, you see that look, they have restructured, they have organized their business in such a way that it harnesses it makes the best use and efficient use of their assets. And the result is obvious. When you check, data shows us that up to 80% of the value of 500 companies is made up of their intangible assets, their IP and their reputation, their brand. And so this is what, so properly managed, properly handled, your IP could, number one, make money for you. Number two, increase the value of your business. And that is why IP is so important nowadays. And in our firm, when we talk to people about IP, we usually address the issue of protection of IP under three headings. We say, number one, you need to identify your IP. If you cannot identify your IP, then you cannot protect it. Number two, you need to secure your IP. If you cannot secure it, then you cannot use it. Number three, you need to exploit your IP. It is when you exploit the IP that you begin to make money from it. But before you can exploit, you must first of all identify and you must secure. When we talk about identifying IP, we have listed this is the traditional form of intellectual property that is available, but of course, new ones are being discovered daily, or should I say annually or yearly, but regularly. So you have the trademark that protects your brand. You have the patents that protects the invention and processes. You have the designs that protect the shape and product model, or shape of the product. You have the copyrights that deals with your slogans, jingles, artwork, software, look and feel of your websites and things like that. And you have your trade secrets that protect your price-sensitive information. This pictograph shows you in a realistic form which IP belongs to what. And we have used a phone, which is what you have, which is one of the most ubiquitous devices available right now. And you'll see in this case, we have chosen an iPhone, and the half-eaten apple is a trademark. It protects the name, the brand, the logo used by Apple, so that you know that once you see that brand on the phone, you know whose product you are taking or you are using. Then you have the registered design, which protects the shape. In this case, as you know, almost all phones have the same shape nowadays. So issue of registered design may be downplayed, but in another situation, for instance, in the brewery industry, where people invest in the shape of their bottle, you will see that shapes of bottles are never the same. There are usually different features to distinguish one from the other. And most of these bottles are already protected. The shapes are protected by the design. Note, it's not the bottle that is protected, it is the shape. Remember that registered design talks to the pattern. We will discuss that further. Then patent protects the working parts, the technology, what makes the phone work. Copyright protects the software that runs the phone, protects the manual that instructs you on how to use the phone, and also protects the websites that you access when you use the phone. So let's quickly discuss these various IP rights in detail. I must say that another one that is becoming very popular now that I did not address in my slide is database rights, which is becoming very popular now in this era of data analytics and data processing. But let's move on to trademarks. Trademarks or service mark simply describes logos, devices, symbols, slogans, or any combination of all of these that is used to identify the source of goods and services and distinguish one commercial enterprise from another. So note, your brand, your logo, that thing that you use that differentiates your goods from the goods of another. So for instance, phone, Samsung, Apple. There's something that distinguishes, they may look alike, but they put something on their phone that once you look at it and you see that thing, you know that, okay, this is a Samsung phone. This is an Apple phone. This is a Huawei phone. Stuff like that. Or when you look at detergents in the soap industry, there's Omo, Elephant, all the other detergents, they have brand names that differentiate the product of one company from another. Those are the trademarks. And the law says that it must be inherently distinguished, it must be adapted to distinguish, and must be capable of distinguishing. It simply means that whatever brand or logo that you have chosen to differentiate your good from another must be strong enough to actually differentiate. So you don't use something that describes the product or that tells a story about the product. And that is why you see someone will use Apple for a phone. Someone will use different things. They have no relationship to it at all. But once it is attached to it over time, it begins to differentiate the product of one person from another. And Trademarks are registered in respect of classes of goods and services. In Nigeria, we use the NIST classification that has 35 classes. Registration is for a period of 7 years and is renewable for a consecutive period of 14 years. So in the first instance, your trademark will be registered for 7 years. At the end of 7 years, if you still want to continue using, you renew for 14 years and you can continue forever renewing for every 14 years. So let's speak about patent. Patent is possibly the most popular among technology companies. And unfortunately, they do not understand that there are certain things that are patentable and there are certain things that are not patentable. A patent is a right granted by governor to an inventor to make use of or to produce or exploit that invention for a specified number of years. Usually, it is for 20 years, provided that you pay your annual renewal fees. Now, in order to qualify for patent, your invention must be new, it must result from inventive activity, and must be capable of industrial application. New means that it is not part of the state of the art. So when you decide to take an existing technology and you change its application, you are not inventing something new. You are just using it in a new way, and that one is not eligible for protection under patent. Another way is an improvement upon a patented invention, so which is also new, results from inventive activity, and is capable of industrial application. So TV, the technology for TV, cathode ray tube, has changed lately to LED and all these new acronyms. And so you can hold it, you can hold technology, you can hold patent in the LED one, and you can also hold the cathode ray and all the improvements, insofar as the technology behind it keeps on changing and it's not part of the state of the art. So in Nigeria, please note that the following are not eligible for protection for the grant of patent: plant and animal rights. So people are into development of new species or improved species, either of plants or animals, or that they are not, all this will not be eligible for protection. Inventions, the publication and declaration of which are contrary to public order or morality, or principles and discoveries of scientific nature. So for instance, if you discover another element on the periodic table now, you will not be entitled to a grant of patent. But patent essentially deals with, so if you find an alternative to internal, so for instance, the internal combustion engine for cars, for instance, the problem is burning fossil fuel and it's causing problem for the environment. Imagine if you can then develop a type of internal combustion engine that it makes burning of fuel more environmental friendly. Now that will be protected. That is capable of being protected by patent. So you need to understand that, and a lot of the times, what you need to understand in this era of digitalization, the argument has been raging for a while whether you can patent digital development or improvement or innovations, to the extent that it is not driven by software. You may be, though the argument has always been, why can't a software be eligible for patent protection? My argument would be that if it is new, if it complies with those three things that we listed: new, subject of inventive process, and capable of technological application, then it should be protected in Nigeria until final provisions are made. In that regard, I will say yes, but I will leave that question to Eno, who is a principal assistant registrar in a trademark patent registry, patent and design registry, to speak to that. So next one is industrial design. Industrial design protects the pattern, the model for a product. So for instance, if I develop a unique model for a car, or I'm selling, I'm selling perfume, and I develop a beautiful product, a beautiful container for my perfume, then the shape, the pattern can be registered and protected as industrial design. But note that that this design must constitute the ornamental or aesthetic aspect of the article. If it has functional capabilities, then it will not. It is the aesthetics of the device that is protected. Design is protected for 5 years, registered for 5 years, and is renewable only 2 consecutive periods of 5 years. You have copyright. Now, copyright deals with literary work. Copyright protects literary work, musical work, artistic works, broadcasting, dramatic plays, sound recordings, and relevant to business. You need to understand that. So when you write out your business plan, it will qualify as artistic work. When you develop an app, I mean literary work. Your business plan will be protected as literary work. When you develop an app, the software will be protected as literary work, essentially because computer programs are deemed to be instructions written for a computer to implement. And as a result, computer programs, softwares, apps are treated as literary work and are protected by copyright. Copyright vests automatically in the creator of a qualifying work. What that means is that I don't need to go and apply specially. The moment I create a qualifying work, it is protected. Now, to then help us with the protection, the Nigerian Copyright Commission has established a notification scheme to determine the date of creation. So how this works is if copyright vests immediately upon creation, when the issue of infringement starts, or when I want to enforce my rights, the issue will then be who first created the work, priority. And that is what the notification scheme helps you to establish. It establishes which one comes first. Now, the fact that yours is registered or notification or you notified CAC and NCC first is not conclusive proof if I can establish through other official means that my work was created earlier. I will leave the director from NCC to speak to this further. But in order to enjoy copyright protection, the work must be original and it must be fixed in a tangible medium from which it can be perceived. If you will remember the celebrated case of Okafor law, among others, but I see Okafor law really buttresses this issue when someone accused Omoni Oboli's company of plagiarizing, of stealing his idea. The court held at the end of the day that copyright protects idea that has been expressed. Whatever idea you have, you do not share it with them in a tangible medium that can be perceived or otherwise communicated. And therefore, it's still an idea, and the law does not protect an idea. So when you have an idea, it's important that you should express your idea in a medium, if it's just to even write it down. And it's at that point that copyright starts protecting that idea. Duration of protection for literary, musical, and artistic work, 70 years from the death of the author or after the date of the publication. For cinematograph, films, and photos, 50 years. What you need to also know that copyright is very funny, unlike what you would think. When you go to a studio and that photographer takes your picture. Copyright in that picture resides in the photographer. And so you need to find a way to ensure that if you want the original, I don't know what they do nowadays. In those days when we were young, they call it negative. In this digital era, I wonder what they will call it. But if that's the case, you need to pay extra to purchase that from him. The same thing too for architects. When you go to the architect and you commission that plan, so trademark copyright in that plan resides in the architect, not you. Trade secrets. This is another form of intellectual property that people hardly ever talk about. It's essentially any confidential information which provides an enterprise with a competitive edge in the market. So TRIPS gives us 3 ways to identify it. It must be secret. It must have commercial value because it's secret, and must have been subject to reasonable steps by the rightful owner to keep it secret. And so this will apply to your business processes, apply to your formula for those who are into biological or chemical processes, the formula for your unique products, how it is mixed, how you get the results, all those things. In food and beverages, how you mix your recipe, along the stages, and how the entire process, how you mix, what kind of utensils you use, what kind of ingredients you use. All those things are trade secrets insofar as it gives you competitive edge over the next person. For trade secrets, we have no law protecting it, so it will be protected under common law. This is one of the gaps in our law that we need to address, so that we begin to take intellectual property protection more seriously. Another IP is domain name. Essentially, this is just your address on the internet. But in view of the perversity of internet lately, domain name has become a key element for harnessing the vast opportunities that internet provides. So that it has become for the fact that it now becomes your identifier on the internet. It has slowly acquired additional function of being a brand, of becoming part of the brand of the company, so that it's just an identifier for your company. And so domain name is slowly becoming very important, and has to be protected too. So now that you have identified your IP, how do you secure your IP? Number one is, for a company, you need to do IP audits. You need to conduct an audit of your processes to identify at which point will IP be produced in my office. How then do we then take steps to protect it? A second step is you need to prepare and implement IP policy. IP policy for employees, IP policy for contractors, IP policy for the company itself. What's a policy? A policy is simply a document that guides you, that gives a guide on how you want to conduct yourself under certain circumstances. And part of the things that your IP policy should be doing is vesting IP created by employees in the company. So where employees create IP in the course of doing the work or using the company's resources, IP should vest, or at least the company's interest in those IP should be clearly stated, so that steps can then be taken to secure the IP. You should ensure that agreements with contractors whose function may result in creation of IP contain IP clauses that vest those IP in the company. So securing your IP simply means appropriating it, taking hold of it, putting in place structures that ensures that you identify IP when it is created and you secure it, you appropriate it, you take hold of it. Because so when you have done that, that you will be able to take the next step. What's the next step? Protect your IP. part of securing the IP. How do you protect your IP? You have three forms of protection. You have registration, which is with respect to trademark, patent, and design, notification for copyright, and then contract for your trade secrets. Registration, essentially, you know what it simply means, an official process by which you are granted a right under law, and that law includes right to exclude others from using your IP, and also provides an ability to exploit that IP by licensing or creating other strategic relationships. Registration is advisable and compulsory in certain circumstances. It is optional in others, but ultimately it's a strategic business decision that has to be taken. So when you want to, so you need to sit down and decide what are the pros and cons for which of the protection avenue or means that you want to adopt. But in doing this, you need to establish a clear process and criteria for deciding whether or not to register IP. It is in identifying the IP, understanding the nature of the IP, that you understand how best to protect it. A good example would be we heard the story about Coca-Cola's formula. Imagine if Coca-Cola had patented that formula about 100 years ago. The patent will have lasted for 20 years, and by now, that formula will be in public domain. Their competitive edge will have been lost. How do you protect trade secrets? Number one is confidentiality agreements. Number two is to safeguard the information, put in place administrative processes that limit access to it. Number four, record keeping, logs. Anybody that will access it must register access, so that way you have a list of people that access it and you can trace leak if there is any leakage. And then you must enforce return of documents that contain the trade secrets. This is key in protecting your IP. Next step is then utilizing IP. How do you utilize your IP? Now, utilization of IP or exploitation of IP. How do you exploit your IP? Exploitation of IP means using your asset in a manner that enhances its value and ultimately improves the profitability of the company. And this involves making a plan. You can see that all that we're talking about is plan. When you understand the importance of your IP, you then put in place plans to ensure that you get the best out of your IP. In doing this, number one thing is you must retain exclusive rights to use your IP. It's important. While IP itself is valuable, what makes it supremely valuable is that exclusivity. I am the only one that can use this important information. And therefore, anybody that wants to use it needs to come and negotiate with me. And that negotiation, the result could be a license or an assignment, it could be franchising, it could be joint venture, it could be merger and acquisition, it could be merchandising, it could be sale, it could be anything. But that exclusivity enhances the value of your IP. But note, if your idea is useless, your exclusivity is useless as well. You have exclusivity in a useless idea. So the idea itself or the IP itself must be valuable. And then the exclusivity makes it more valuable in that people need to come and talk to you to get it. Imagine someone trying to use Davido or what's his name, Burna Boy's song, either as an advertisement or anything. They must talk to him first because he has the exclusive rights in the music, and then he will be able to then charge whatever he wants to charge. So, in conclusion, what do you need to do to ensure that your IP is protected and that you can make the best of your IP? Number one is to understand the importance of IP in your business. Remember what I said, it confers unique competitive edge on your business. And because of that, it needs to be protected. Two, the moment you are able to harness and protect your IP, it creates value that you can unlock through strategic relationships. And therefore, stage one is you need to conduct an IP audit to identify which IP is where. And then in the process, valuation, so that you know what your IP is worth, you know the stage of your IP, you know whether the IP is protected or not, you know whether this is even the best form of protection for it or not. Two is to prepare and implement an IP policy. They say prevention is better than cure. IP policy helps you to prepare. It is not the day that your IP is infringed or stolen that you should start taking steps to prepare. The day that you plan to create the IP is the day that you should start planning to protect it. An IP policy helps you to take a proactive step in that regard, because everybody knows what they are supposed to do the moment it occurs. Three, IP training awareness among your staff. It is never too late. Knowledge is never wasted. Train, retrain, refresher course, let everybody know what to do, so that the moment it's part of identification of IP. Once they are aware, they will be able to identify IP when it's being created. They will be able to identify loopholes in your system where IP can be stolen. One of the biggest ways in which IP is stolen is when staff leave you and carry knowledge and download files and take it out with them. Part of what your IP policy needs to be doing is to be addressing issues like that. Safeguarding identified IP assets, registration, non-disclosure agreements, and all those things needs to be in place to ensure that identified IP assets are secured and protected. Remember that I said that the exclusivity conferred by law makes your IP extremely valuable, because you can then trade in the IP. IP is so unique that you can sell the same IP, or you can trade the same IP to different licensees per geographical region. You can have a licensee for Africa, you can have licensee for Europe, you can have licensee for Asia, or you can have licensee for Northern America and Northern Africa, you can have for Southern Africa, you can have for the different regions in Africa, depending on how valuable the IP is. But in the first place, it must be secured and protected. Two, create market awareness. When you see certain advertisements, you will see C in circle, you will see TM behind certain names. It is to warn the market that this brand is protected. So those are the steps you need to take as well to create market awareness of your IP. And lastly, but most importantly, work closely with your solicitor. Get a lawyer. Lawyers have become indispensable in this day and age. Not only do you need a lawyer, you need a subject matter expert. Lawyer no be lawyer. We are not all lawyers. Jack of all trade is a master of none. If you get a general lawyer that does everything, he will give you general advice. If you get an expert who specializes in a particular field, it gives you deeper and more focused advice. Don't go and get a litigation lawyer to come and advise you on IP unless the litigation lawyer is experienced in IP litigation. Don't go and get an oil and gas lawyer to come and advise you on IP unless the oil and gas lawyer has experience in IP. I guess that is all for me. To round up, I've shown you this before, as a refresher, just note what I have said. The logo is protected by trademark. The shape is protected by registered design. The technology that runs it is protected by patent, while the software the interface, the website, the manual, protected by copyright. Thank you very, very much. Any questions? Do I still have time to answer questions?
I think we would take the questions subsequently.
All right then.
Yes.
I hope I finish within time.
Thank you very much, Mr. Alumide Oshunjulire. And so without wasting more time, I think we would move on, right? And I think we'll be moving on to the panel session. I would like to introduce the rest of the speakers or the speakers for the panelists for that session. Like I said when I spoke earlier, we have quite a number of interesting and well-versed speakers for this interactive session. We will take the question and answer after that. Like we said earlier, please write down your question in the chat box. We don't have a separate space for questions. So quickly, I will run through the just brief bios of the speakers that we have so that we understand the rich array of speakers that we have for this panel. I'll start with Dr. Dan Azumi Mohammed Ibrahim, who is the Director General of NOTAP, that is the National Office for Technology Acquisition and Promotion. Dr. Dan Azumi Mohammed Ibrahim, the DG of NOTAP, started his working career as a lecturer in the Faculty of Agriculture, Department of Soil Science at the University of Maiduguri, and then he later joined the Raw Materials Research and Development Council, where he rose to the rank of Deputy Director. He joined NOTAP from the RMRDC in September 2010 as Acting Director, Technology Promotion and Commercialization Department, and was elevated to the position of Director in December 2014. He has undergone many capacity development programs, including international trainings on strategy for sustainable agricultural development at the Institute of Rural Development, Hyderabad in India, and international training on breeding of horticultural crops at the Institute of Vegetables, Flowers, China Academy of Science, Beijing, China. Dr. Ibrahim has many scientific publications to his credit and has handled many assignments for the federal government of Nigeria and international organizations. He is currently a consultant to UNIDO on establishment of neem-based biopesticide in West Africa, and a member of international experts on the development and implementation of ECOWAS policy on science and technology, ECOPOST. He's a founding member of the Neem Association of Nigeria and a member of Soil Science Society of Nigeria and Fisheries Society of Nigeria. He was the director of the Technology, Innovation and Commercialization Department before his appointment as Acting Director General. His special interest is in human capacity and institutional development to reduce dependency on foreign technology consumption and sports, particularly hockey, where he represented Nigeria in international competitions and won many laurels. Dr. Ibrahim, you are welcome to today's program.
Thank you very much.
You're welcome, sir. The next person on the panel is Ms. Linda Alpheus, who is the Deputy Director Legal, Nigerian Copyright Commission. Linda Alpheus is a seasoned legal practitioner with a master's degree obtained from the University of Lagos in 1997. She has gone through diverse trainings, both locally and internationally, in intellectual property, with particular emphasis on copyright. She's a counselor and a teacher who believes in giving back to the society through enlightenment of intellectual property rights owners with tools and life lessons that will change the trajectory of their lives and community. With her experience as a prosecutor with the Nigerian Copyright Commission, she has been involved in conflict resolution, arbitration, mediation, and the prosecution of copyright infringers. She is currently the head of the legal department of the Nigerian Copyright Commission, Lagos Directorate. Ms. Alpheus, you're very welcome to today's program. The next on our list is Ms. Eno Obong Usen. Eno is the Principal Assistant Registrar at the Patents and Designs Registry. Eno Obong Usen is the Principal Assistant Registrar at the Trademarks, Patents and Designs Registry, Commercial Law Department, Federal Ministry of Industry, Trade and Investment. She has over 12 years experience in the field of intellectual property rights with focus on patents, industrial designs, and trademarks. She has functioned in various capacities in the Trademarks, Patents and Designs Registry and gained practical experience handling issues bordering on this subject. She has served as an expert member of the Nigerian delegation to the World Intellectual Property Organization, WIPO, at the Geneva Assembly at various times, an understanding committee on the law of trademarks, industrial designs, and geographical indication. Presently, she serves as an expert member of the Nigerian delegation to WIPO Standing Committee on the Law of Patents. She has also served as a lecturer at the World Intellectual Property Organization Academy in Geneva. Enobong holds an LLB from the University of Uyo, Akwa Ibom, a master's degree in law and policy from the University of Lagos, and a master's degree in intellectual property from the University of Turin, in conjunction with the World Intellectual Property Organization Academy. She has also trained with the United States Patent and Trademarks Office and the Norwegian Patents and Trademarks Academy. She's an alumni of the International Visitor Leadership Program, IVLP, USA. As part of her passion for intellectual property, she works with the eco-inventing community on the registration and protection of their intellectual property rights. Enobong Usen, you are very welcome to today's program. We're happy to have you today. And we have Odunoluwa Longi, the co-founder, DIY Law and the Longi Practice. Odunoluwa is co-founder of the Longi Practice Advisory, a venture law practice where she represents venture builders and their funders, and DIY Law, an award-winning and leading legal technology setup in Africa. She's also the Innovation Hub Head for West Africa at The Hill, the Hague Institute for Innovation of Law. Odun used to work in investment banking, and her educational background includes a master's in law and business administration from the Northwestern Pritzker School of Law and Kellogg School of Management, respectively. She wrote the chapter on Future of Law, Increasing the Access to Justice Through Technology in Technology, Innovation and Access to Justice, Dialogues on the Future of Law, published by the Edinburgh University Press. Apart from work, Odun is an experienced entrepreneur and is deeply passionate about impact, social justice, and change. She's a technophile whose career is an embodiment of these passions: entrepreneurship, technology, social change, and justice. In addition to being an experienced and knowledgeable venture lawyer that specializes in technology and fundraising advisory, her core competencies lie in strategic partnerships, business, product and organizational development, commercial strategy, leadership and people management, and client and customer success. And then last but not the least, I would like to introduce Adenike Ademi, who is the moderator for this panel session and the executive director at Faith Foundation. Adenike is an innovative thought leader with 19 years experience in strategic planning and institutional transformation in the nonprofit, private, and public sector space. As the head of Nigeria's foremost enterprise development organization, that is the Faith Foundation, she leads the fulfillment of Faith Foundation's mission to enable aspiring and emerging Nigerian entrepreneurs start, grow, and scale their businesses, and has led the development of 12 research reports on the Nigerian entrepreneurship ecosystem and also 7 books for Nigerian entrepreneurs. Through digital transformation and key partnerships, Adenike had led the team to launch signature incubator and accelerator programs and to reach 24 states and 180,000 entrepreneurs. She is a 2020 Eisenhower Global Women's Leader and also serves on various boards, including the Youth Business International, Lagos Chamber of Commerce and Industries, Budget, VDT, Bitflux Communications. She's also the lead facilitator of the NESG MSME Community of Practice. So thank you so much. And without much ado, I'm going to hand over this session to Adenike.
Thank you very much, China. So I think that one thing that is very clear is that we have a very powerful and very experienced panel who either are personally and or institutionally involved at different aspects of the intellectual property space. So you're all welcome to the interactive session that we'll be having. As Chinasa had said earlier on, please can we put our questions in the chat box? We will be directing questions as required for this conversation. Thank you, Olumide, for really laying the groundwork for the conversations today. The theme for this year's WIPO conversation is IP and SMEs, taking your ideas to market. And I will add, and making it marketable, because you can, from Olumide's conversations, you can take it from market, but so many other things that can happen that it may end up not even continuing to be a viable and feasible idea that you can extract benefit from. And his conversation really broke down the key elements of what intellectual property is, how to understand it, how to secure it, and how to monetize it in different ways. And those and many more will be what we'll be exploring. I think one of the important things to notice, and I didn't actually realize this until I joined Faith Foundation, that a lot of times people think of IP just from the component of maybe from technology, particularly those who do software and all of that, and then a bit of entertainment. But the spectrum covers almost all, if not all sectors, because at some point or the other, you're creating a brand image or a brand identity for your product, you're packaging your product, you're bringing knowledge and intellect to develop what you will sell, even as a consultant. And then you're interacting with different levels of IP. So even if you're not developing your IP, you may be at risk of even infringing on another person's IP and even things around, if we look at the way digital is and how people promote their brand, if you look at even like Instagram Reels or YouTube videos, people using other people's songs without permission, or as we've seen, a lot of people copying other people's products in different ways. So those are some of the things that we would explore, but in a very practical way, because I'm aware we're speaking with SMEs who have lean teams and who are looking for and who we want to understand the importance of the role of IP, but also be able to implement this in a very efficient and very practical way. So I really would like to welcome all our guests onto the panel. And I would like to start with Dr. Mohammed. You're welcome, sir. Dr. Mohammed is the DG for the National Office for Technology Acquisition and Promotion. And the first question I would like to ask, and I'm asking this to you in the sense of you even doing sort of like an opening response to the conversation. What is the role of NOTAP in helping to secure in the IP space and the continuum, and even helping to secure like IP for people? I know that NOTAP is sort of like a gateway, particularly for external, for foreign inventors in different forms across the technology space. But what is the role of NOTAP in terms of helping to enable and secure IP, and how can SMEs take advantage of the programs and initiatives that NOTAP oversees? Over to you, sir.
Well, thank you very much. First of all, I would like to, on behalf of the staff and management of NOTAP, express our appreciation for the invitation, particularly to Banwo and Ogoda. And the presentation made by Olumide was quite extensive. So I want to be happy to be part of these discussions. So coming back to your questions, yes, what demarcates between developed and developing nations are their ability to convert their intellectual assets into product and services for economic development of the nations. At NOTAP, we register technology transfer agreement And we see the quantum amount of technology that comes into this country. And these technologies come into this country not free of charge. We have to pay, and we pay heavily through licensing. So as a nation that is aspiring to become economically independent, we cannot afford to continue business as usual. We have to ensure that we put in place some strategies that will ensure that we get the best out of the relationship. How do we do that? From the information available in our database, more than 90% more than 90% of the technology that power the Nigerian economy are imported. Is it in the manufacturing sector? Is it in the industrial sector? Is it in the ICT? In any sector you can think of. And since these IP assets are products of mental activities and are product of research and development, we expect our universities, our research establishments to also come out and undertake some researches and come out with technologies that would gradually begin to reduce dependency, remove us from the shackles of dependency. So what is happening is, since research and development is a major function of universities, research establishments, and polytechnics, if you look at the funding aspect, is very, very weak, and research and development is most affected. But despite the fact that the funding is so weak, still innovations and inventions come out from our universities, from our polytechnics, from our research establishments. So it's for us to now begin to understand how we combat these resources or intellectual assets into product and services for the financial or for the economic development of our nation. So, but we realize that apart from the funding, we have a very weak IP protection culture in the universities. The researchers, yes, despite the funding is weak, they still come out with some innovations that have the potential to translate into product and services. But they're in a hurry to publish and tell the whole world that, yes, I have done this, I have reached this, I've done that. Once it is in a public domain, it is now in public, once it is in public domain, the author or the owner of that intellectual assets will not have monopoly to reap any economic value out of it. So NOTAP as an institution saw a gap and felt that how do we fill in the gap? We started a program with World Intellectual Property Organization in sensitizing the researchers, particularly in the universities, research establishment and polytechnics. We established what we call technology transfer, sorry, intellectual property and technology transfer offices in the universities. What we do is we go into the universities, they give us a space, we furnish it, we provide all the infrastructures, we train Nigerian lecturers, enlighten them on the need to protect their intellectual assets. And any innovation that is coming out from the universities, they approach us, we help them where necessary to fill the relevant forms, write the relevant claims, take it to patent registry, pay the patenting fee, collect the certificate. We only call them to come and collect their certificates. When we came on board in 2015, I think we've been only able to assist in patenting 6 technologies at the patent registry. But in 2016, we doubled our effort and we assisted further 16. By 2017, the number rose to 50. By 2018, the number rose to 57. That means the intervention is working. So what we insist is, because it is the first stage of commercialization of any R&D, you have to protect the intellectual asset. Commercialization of intellectual asset is a private sector affair. And like the speaker said, nobody will put his own money where the intellectual asset is not protected. So that is the first stage of commercialization. The other issue is, after patenting the technology, what happens? If those technologies are not converted into product and services, then they have little or no value into the system. So we also think of how to bring in the industry and the academia together. Because currently what had been happening, The industries are looking at one side in terms of their research and development efforts, and the academia are also looking at another side. And unless they come to converge, we may not see research and development efforts in Nigeria translating into product and services. If that doesn't happen, for a very long time, we remain a consumer nation, and there is a price for that. So what we try to do as regulators, where we see opportunities, where we insist some industries must have to use the resources available in this country. I can tell you one instance. When a company brought its registration agreement for us to register, we saw a situation where they are importing calcium carbonate from China. And we're asking, we have several deposits of calcium carbonate in this country. Why must you have to go as far as China to import calcium carbonate? The answer given to me by the MD was Nigerian calcium carbonate has a lot of quartz that affects their machinery. Then we say, okay, if it is quartz that disqualifies Nigerian calcium carbonate, we have to bring in a technology that should remove the quartz from Nigerian calcium carbonate so that it meets your specification. Since we give approval after every 3 years, we say the next cycle of agreement may not be registered unless you do something. Bring in the technology. I'm happy to say now, they collaborated with some of our institutions and some local industries here. And within 1.5 years, they've been able to refine Nigerian calcium carbonate to reach their own specification. That is a strategy. So long as our intellectual assets or intellectual activities doesn't translate into tangible product and services, it may have little or no value to it. So now, when we come to the software also, if we give 10 approvals to, if you have 10 requests today, and we give 10 approvals today, at least 6 to 7 are on software. And we have seen a lot of money that goes out of this country as licensing. No, any patriotic Nigerian will not feel the pain. But we have to now come with a strategy for us to remove ourselves from those shackles. We sat down with relevant stakeholders, Nigerian software developers, other stakeholders. What can we do to get the best out of this relationship? We came out with a policy of local vendor. What does the local vendor policy entails? It entails that any software, registrable software that is coming into this country, before we register it in this office, there must be a Nigerian IT company that should be involved in the deployment of that software and should be involved in the maintenance of that software. The strategy is, if you involve intelligent Nigerians into the deployment, into the maintenance, whether the original equipment manufacturers like it or not, good part of you will be captured by Nigerians. So we are developing the capacity of Nigerians. So since licensing is normally one-off, but there is another caveat where after every 1 year, you give to the owners of the softwares between 13 to 23% of the licensing fee as maintenance. We insist that if a Nigerian IT company is involved in the deployment, is involved in the maintenance, you understand? 40% of that ATS must be paid to Nigerians. So that would give them some kind of financial muscles that would help them translate what they have learned into tangible product and services. I'm telling you, after 7 years of enforcing this policy, it was not without resistance anyway. We now reevaluated and discovered that within 6-7 years, we have seen the quantity number of intellectual Nigerians that have developed their capacities in terms of software development and application. For those of you who are in Lagos, if you know Computer Warehouse Group 7-8 years ago, and you go there right away, you will be amazed the kind of capacities they have built. And the 40% they've been getting, the kind of infrastructure they have put in place. I'm happy to say that they have even now started exporting software across the Nigerian shores, across the West African region. That is a strategy. So for us as a nation, we have to work hard to ensure that our industries and academia are working together. Unfortunately, most of the manufacturing industries are foreign based. They do their research and development outside the country, not in this country. but where we feel we have Nigerians who are capable of undertaking one or two things of their research and development, we insist. The other issue we came out with, the industries as part of their corporate social responsibilities, they have to develop and work with the Nigerian researchers to undertake research and develop their capacities. So we ask the industries, at the end of every year, give us areas of your research and development where you feel Nigerians can participate. We should list those areas, we advertise, and Nigerians applied. We kickstarted this program in 2016 with 5 companies sponsoring 5 candidates. And the research and development of those candidates are based on the operations of those industries. The idea is, by the time the research and development is concluded, it is almost ready for commercialization. I'm happy to say that one of the candidates who had worked on winning feed and sponsored by Nestle has already completed her PhD. And it has a potential that probably Nestle may now open a production line to begin to translate that technology into product and service. That is a strategy. So after the first segment, we have additional 10 companies sponsoring additional 10 candidates who have finished their masters and they are going for PhD. That are critical areas we want to develop the manpower. So now bringing the industry and the academia together, it what would ensure sustainable development. So you should not be under any illusion that particularly the multinationals are interested in developing their country. No, their interest is to come and make money and take the money out of it. It's for us as a system to develop strategies so that we can get the best out of the relationship. Apart from the sponsoring of the research and development in the universities, we also told them as part of their corporate social responsibility, even if you have the capacities developed, you go to the laboratories in the universities, some of the equipments are obsolete. So for you to undertake credible research and development that could translate into development of technology, you have to have good and sound equipment. We feel as part of their corporate social responsibility, instead of them to go to the village and dig a borehole, let them also provide functional laboratory equipment to the institutions. I'm happy to say that PZ Nigeria Limited has keyed in. And in its first segment, it committed a sum of 150 million and upgraded 3 laboratories. Those 3 laboratories have been upgraded and commissioned, one in the University of Calabar, the other one in National Research Institute for Chemical Technology, Narik Zaria, and another one in Modibo Adamawa University of Technology, Yola. And those 3 laboratories were fully commissioned. The minister was there, the MD of PZ was there physically. But what happened after was the research and development team of PZ now went round to those 3 laboratories to see how they can forge a partnership to undertake joint research and development. With the success of the first 3, now PZ is further committed to invest the sum of 360 million to upgrade additional 6 laboratories, 1 in each of the geopolitical zones of this country. So far, additional 2 have already been commissioned. 1 in Alex Akweme University of Federal University of Technology in Ebonyi State, Aleke Ndufu, Ebonyi State. And one important thing that happened, before those equipments arrived in institutions, the institutions was in their need for getting some of their courses accredited. So with the availability of those equipments, all the courses in that department became accredited. That is a plus. The second one under the second segment is Abubakar Tafawa Balewa University Chemical Engineering Department. Now Bauchi is hopefully will be among the oil producing states. NNPC is trying to see how that laboratory would be utilized to enhance oil exploration. So what we have to do is there must be a synergy between small and medium industries and our research establishments. And for the multinationals, we just need to be strategic. And for our indigenous industries, the small and medium ones, they need to work closely with the researchers in the universities, in the polytechnics, so that they could help them translate what they have been laboring for a very long time to come with a technology that could translate into products and services. These are some of the things. Thank you.
Thank you so much, Dr. Mohammed. You have been able to succinctly not just respond to the first question I had, which was really giving an overview of what NOTAP does and the role they play, but answered the second question I was going to ask, which was how does NOTAP foster local innovation and development? One of the things that has struck me in your conversation is the triple helix model that you're adopting, bringing in academia, bringing in industry, and bringing in innovation. I know that there are about three people on this call who are students from colleges of science and technology in a Southwestern institution here. And this is also very important because, again, if we don't build it up from academia, that's really what changes what's happening. Now, we've seen that across different sectors, whether it's biotech, health tech, agri-tech, in all the different dynamics that are critical sectors of Nigeria. We need those innovations. And yes, you know, it's interesting to hear the statistics that a lot of the innovations are imported, but it's also good to see the growth in the development of local innovation and also even in the export of local innovation. So I'm going to come back to you later on to ask you how SMEs can find out about some of these opportunities you're talking about and how they can key into it. So thank you very much. Thank you very much, sir. My next question would be to Ms. Linda of the Nigerian Copyright Commission. And again, in terms of copyrights, I look at, when Olumide gave his presentation, I looked at copyrights from two angles. We have a few of the entrepreneurs who are here who are within the creative space, whether in terms of music and all of the other components of it. So they're the creators. And then we have people who are users of that. So my first question to you would be, how does one go around the copyright process? We have a lot of people who are really very innovative and creative and all of that. How does one go through the copyright process? And what are the key things that from the NCC's perspective, an SME who is looking to process their copyright needs to be cognizant of? Thank you. Over to you. We can't, I don't know if it's me, but I can't hear you. I know your mic is off. Chinasa, can you hear her? We can't hear, your mic is off, but we can't hear you. Okay, so may I ask that you should, if you can quickly sign out and sign in again, and then we'll come back to you because it may be a connection issue. Thank you very much. So while we're waiting for Linda to sign off and sign back on, I'm going to go to our third panelist, who is from the Federal Ministry of Industry, Trade and Investment, in particular, the department responsible for trademark, patents, and design. Ms. Enobong, you're welcome very much to our panel conversation.
Thank you.
Yes. Mm-hmm. So the question that I have for you, and we've had about two questions that are related to that, not just in terms of talking about the role that you play and the department in particular, and I think it's very crucial to see that the department is housed within the Ministry of Industry and Innovation, or FMIT, Industry, Trade and Investment. What are some of the options for innovators who are looking in the hardware process? So to provide a bit more background on that, a lot of times when people think about innovation, they think about innovation from the software perspective, but we are seeing quite a lot of innovation even from the hardware perspective. So we have a lot of people who are fabricating or designing hardware products or hardware innovations that are solving critical things. I can use an example of two sectors, the health space and the agribusiness space in particular, where even we have seen over the last 2 years quite a lot of increase around that. What are some of the options and the opportunities presented by your department in helping to encourage and to enhance those kind of innovations? And what is the role, what are the important things that they need to think about from a patenting process? Thank you.
Thank you very much. So in our department, we help inventors to register we grant patent rights to inventors. That is people that have invented something new something that has never been in existence before. And what we basically do, the essence of this right is, the government recognizes that it takes a lot of effort in order to come up with invention. And there's no way it can actually, no monetary value it can actually give to the inventors to appreciate them for their hard work. And so the only thing that the government thinks would be appropriate is to give them a monopoly for a period of 20 years. These 20 years represent the lifespan of the patents. And it is presumed that within this period of 20 years, the inventor will be able to recover the cost of his investments through maintaining monopoly in the market. Maintaining monopoly in the market means that no other person can work the invention, sell it, import it, or otherwise deal in the invention without his consent. And of course, consent is not given free. So the government believes that he'll be able to put a price to his consent, so he can determine how much money he would, the person requesting for the consent will have to pay in order to have a consent to work the invention. And this is given for a period of 20 years. So within this 20-year period, the inventor maintains a monopoly in the markets. Now, the patent right is usually seen like as a bargain between the inventor and the government. The inventor is supposed to normally referred to as the patent specification and claim. The disclosure document tells the government about everything about the invention. And the essence of this disclosure document is so that invention is not stifled, technology is not stifled, meaning that while this 20-year period lasts, anyone should be able to have access to this invention or to this disclosure document to see what the inventor has actually done. And if he feels that there's need for him to use his invention in order to be able to achieve the new invention that he intends to come up with, he should be able to approach the inventor for consent. And after the 20-year period lapses, let's presume that the inventor cannot be found. Anyone should be able to use this invention in order to be able to advance technology. So that's the essence of the disclosure document. Then, as opposed to ideas, it is inventions that are actually registered or granted patent rights and not ideas. Ideas, when it's metamorphosis into invention, are the ones that the patent right is concerned about. The patent rights are territorial rights, meaning that you cannot have a patent in Nigeria and hope to enforce it in Ghana, because every country has its own laws. What might be a patent in Nigeria may not necessarily be a patent in Ghana. So if you want to have a patent in Ghana, you have to go to Ghana to also apply for the patent rights. Another thing I would like to also add is that there are two types of patents in Nigeria. We have the conventional patents and we have the non-conventional patents. The conventional patents are broken down into two types. We have the foreign patents, that's patents that have actually been granted in another country, and the applicant wants to also have the invention protected in Nigeria. We have the PCT patent, that's patent that comes in via the PCT route. The PCT route is a special kind of a patent filing that is being administered by the World Intellectual Property Organization, WIPO, in Geneva. We also have the non-conventional patent, which represents local patent filing. Now, in order for you to patent your product, you have to ensure that the patent you have to ensure that three basic requirements has been met. First, the patent has to be new. Novelty is always of essence, and novelty is universal, meaning that you cannot be importing product maybe from China and you come to Nigeria to register it as a patent because you are obviously not the inventor. We have seen instances like that, whereby people who are importers suddenly want to turn the inventor because the product has not been registered in Nigeria. Also, you cannot start a manufacturing plant. Maybe you want to manufacture maybe pencils, and then you come to register it as a patent in Nigeria because there's nothing new about pencil. Pencil has already been in existence and there's nothing new about the method of production. Secondly, your patent has to have an inventive step, which is non-obvious to someone of ordinary skill in the arts. And then it must have industrial application. It should not just be a product that is just on your shelf that cannot be used in the industry. Another thing I want to add is that for the disclosure document, which is always of essence, it has different structures that it must have. First, the title of your patent. The title of your patent should be able to tell us what exactly you have invented. The title of your patent is not your trademark. It should be just a brief summary of your invention. Secondly, it should disclose the field of invention. We should be able to know the scope of the invention. Also, you should have a background. You should tell us the background of the invention. What is it that is already in existence in that field of technology? And what are the lacunae which your own inventions seek to solve? Thirdly, you should tell us the object of the invention. You should be able to briefly tell us what is the object of the invention that you want to protect. And then the summary of the invention as well. Also, if you have pictures or drawings that could, support your claim, you need to also include it as part of your patent disclosure documents. When all this is done, the patent office will look at it and determine whether or not you should be granted the patent right. Once the patent right is granted, you have a responsibility to ensure that you pay your renewal fees as when due. Renewal fees is usually due on the anniversary of the patent, and this is what keeps the patent alive. The lifespan of the patent starts to run from the filing date, but technically speaking, after a year, if you have not paid your renewal fees, the patent lapses and falls into the public domain. Falling into the public domain means that it's really available for anybody to use, and you cannot sue them on it. So I'd like to stop here.
Thank you very much. Thank you. You've started answering some of the questions that we've gotten, but thank you for providing in a bit more detail the types of the patent and then just even the process and what is required. One of the things that you've emphasized is something that Olumide also spoke about very consistently. They need to document, they need to be clear. They need to showcase exactly what's the differentiation and the innovation factor, and also the need to also be certain that it really is different. The question a quick question that I want to ask you: who is responsible to fish out the infringements for patenting infringements? Who is responsible?
Okay,
is the responsibility on the innovator, on the regulator, or all of the above?
Okay. The patent is an intellectual property right.
Yeah.
An intellectual property right, just like every other property, like your landed property. If there's an infringement, you are the person that will go ahead to fight for it. So the responsibility is always on the inventor, on the patentee, because once he's granted a patent, he's not we regard him as the patentee. So the responsibility is on him to make sure that his patent does not lapse or people don't infringe on his patent, not on the government.
Thank you very much. Thank you. And to Chukwuemeka's question, if I get a patent in Nigeria, that doesn't infringe on somebody in China. That doesn't forbid somebody in China for infringing it, because the laws are very different and it only covers the innovator, the inventor within the Nigerian space, so to speak, right? Just to confirm that, because that was the question we had.
Well, actually, different countries have their own different laws. So what can be a patent in Nigeria may not be a patent in China. So if you want your product to be protected in China, maybe because you are producing your product there and importing it to Nigeria, you have to also make sure that you go there and obtain a patent in China.
Thank you so much. Thank you very much. So I don't know if Linda is back. But
hello.
Yes. Okay, great. You're welcome. Fantastic. You're welcome back. And we can hear you now. So I'll just go very quickly into my question. How do I go about the copyright process for my song idea, my creative talent idea? How do I go about it? What's just in a very simple way, how do I go about getting the copyright?
Thank you very much.
Creative idea? Thank you.
Thank you very much, Mr. Denike. I would first of all start by saying that a lot of SMEs create and use a great deal of copyright works.
Yes, so that was my second question, because that really is another dynamic, but I'm happy for you to answer the two at once. Thank you.
Okay, so they create a lot of copyright works in the process of producing and service delivery. But unfortunately, some of them do not even know that the works they have created are copyright works. So first of all, I believe the first thing an SME needs to know is to have an understanding of the meaning of copyright. What does copyright give you? What kind of rights do you enjoy under copyright? I know Mr. Olumide has done some of that, but I would like to say that, first of all, your copyright in a work, hello, I'd like to say that, first of all, you must understand what it takes for you to create a copyright work. I'm interested in the topic which says taking your ideas to the marketplace. But unfortunately, when you are talking about copyright does not protect ideas. What copyright protects is the expression of the idea. So what that means is that if you have a whole big idea about how to do something, or you want to how to write a story or something, and it remains at the stage of idea, you will not be protected by copyright. So you must understand what it takes for you to be eligible for copyright protection. And what does it take for you to be eligible? First of all, your work or your idea must have been fixed in a medium capable of being perceived. What that means is that you have either written it down or you have recorded it in a digital form on a CD, but it must be fixed in a way that people can access it. Then another thing about your work, for it to be eligible for copyright protection, it must be original. Copyright does not expect your work to be novel. However, it must have some bit of original character, so that if, for example, you create a work, somebody else can create a work that has the same idea, but certainly there must be some distinct character. Your character must be inputted into that work. So for an SME, for example, you want to be protected by copyright, your work must be fixed, then it must have some original character. Then going from there, what do we do? Some of these SMEs have copyright already. Some of them have developed softwares. Some of them have developed websites. Some of them have developed computer programs, and they don't even know they are eligible for copyright protection. So what do we do from there? First of all, you must, if you have fixed your work and it has an original character, you must, in the first place, immediately you create that work and it's original, you do not need to register before you enjoy copyright. Copyright is automatic, which means immediately certain works are created, you already have copyright. But then you need to go further, because if you don't know you have copyright, you will not even know the bundle of rights that the law gives you. What is copyright? Copyright is a bundle of rights that the law gives to creators of certain kinds of work in the artistic field, in the musical field. So if you have these rights, you have a bundle of rights, not just one right, a bundle of rights. The right to reproduce, the right to adapt, the right to the right to production. All these rights are yours if you have a copyright. So what they must know is the importance of copyright to them. As an SME, for example, you have a software which you have developed, which you use to make business which you use to make your business easier. You should identify the fact that this is a copyright work. So if you understand that it is a copyright work, you should know that this belongs to you. The law has given you the exclusive right to use this work, and nobody else has the right to use that work. So if somebody, for example, is infringing on your work, you must take it up immediately. Do something about it to help protect your work. Copyright gives a whole lot of advantages to SMEs. Some of them, it helps sometimes, for example, copyright helps you to develop your business, to grow your business. I mentioned earlier that some people have some softwares they have developed. Some people have advertisements they have used to sell their business. Some people even have things like data of customers, which they have built. They have copyright on these things, and it will help every business. It will help you. Though the right the copyright law gives you is intangible, but by the time you are able to legally protect your copyright, it transforms into exclusive proprietary enterprise for you. So it's the right you have in your copyright is as good as any property. It's as good as a building. It's something that you can transfer. It's something that you can sell. It's something that you can license. So at the end of the day, it's helping you to build your business and make a lot of money if you can find a way to understand copyright and harness the rights that the law has given to you. Another advantage that this copyright gives to copyright owners is that it helps you to improve your reach. For example, if you have a website from which you can advertise your product, sell your product, you can be in Nigeria doing business in Nigeria, and you are advertising your product all over the world, selling all over the world, because you have a website where people can reach you. These are some of the advantages the copyright owner has. Now, I mentioned that copyright endures automatically, which means you don't necessarily have to register your copyright. However, the Nigerian Copyright Commission has developed a scheme which we call the Nigerian Copyright e-registration scheme to help copyright owners register their scheme. It's not that you actually need to do that before you can enjoy copyright. No, but there are a lot of advantages in doing this. Number one of the things it does for us is that it helps us keep a database of authors and their works. So the works of authors are registered, they are recorded, and the record can be accessed by anybody. So that at any time, if there's a conflict as to who owns which work, the people can always refer to the database of Nigerian Copyright Commission in order to ascertain who owns what work. Mr. Olumide also mentioned another one, which is priority. The fact that you register your work gives you a priority. If you have created a work and you register it, it gives you a priority, so that in future, you can always say, I registered my work in the year 2020 at so and so time, so that if somebody does a similar work or something copies your work and later comes up with such work, you can always refer to that data bank and say, no, this is my work. Now, another advantage that you get from that is that it helps determine ownership. When you register your work, like I said earlier, it's not the registration that confers copyright, but gives you a lot of advantage. At any time, you can claim ownership of your work. You can exploit your work, manage your work, and be able to protect your work. Then sometimes we get inquiries from foreigners who want to know, I'm interested in this work, I want to know who is the author. That data bank that we keep helps us to inform them or to advise them on who owns which work. So these are some of the advantages of coming to the Nigerian Copyright Commission to come and do this e-registration. It is all in the interest of the copyright owner. So we encourage them to do it.
Thank you very much. Thank you. Is this e-registration, can you give us a link to it? If you can provide it in the chat window, whether it's the process or even the database, the e-register itself, is it possible to provide that link for us in the chat box?
Yes. I'll provide
it. We'll wait for you. So we'll wait out for that. Yes, okay, if you can put it in the chat box for everybody to have access to it. And just to clarify something, because we had 2 questions on that. If I don't register my copyright, do I still have right to take somebody who infringes on it to court?
If you don't register your copyright, as the law is in Nigeria, you still have a right, because copyright endures automatically. So you have a right to protect your copyright at any time.
Fantastic. However, thank you very much.
If this work were registered, you can even call on Nigerian Copyright Commission, who can come and give evidence as to the fact that this work belongs to you.
Okay,
so it gives you a better advantage.
So the ideal is to just go through the registration process.
Yes, that is the ideal thing to do. Fantastic. Yes, we advise it.
Thank you very much. Thank you. To our last, but definitely not our least speaker, who is wearing 2 hats. She's wearing the hat of an entrepreneur herself, and also the hat of an advisor, legal advisor, who has also supported quite a lot of entrepreneurs on their IP process. Odunlonge, you're welcome. Sorry, I'm very familiar with you, so I'm assuming that. So I have 2 quick questions for you. Number 1, what are the common mistakes that entrepreneurs and SMEs in particular make when going through that IP process? And I know we recently did one with you, so I understand that. So what are the common mistakes that SMEs make when going through that process? But then on the supply perspective, so on the regulatory perspective, and you were in the heart of an entrepreneur, what do we want our regulators, what do we want NOTAP, NCC, the Department of Patents and Registry, what do we want them to know that is crucial to enable SMEs make sure that they take advantage of the provisions that intellectual property avails to them? Thank you.
Thank you very much, Nike. Thank you for having me here. And it's a privilege to be on the same panel with all the distinguished speakers. Thank you very much. Let me start with the first question, which is, in fact, the common mistakes entrepreneurs make. The most common mistake is something every speaker today has touched on. Many entrepreneurs believe that they can protect ideas. There's this common misconception that, okay, this is what I want to do. Can I get copyright for this? So the first thing, I often try to do is, if it's not in any physical form, if it's not been expressed, you can't even use an NDA to protect an idea, at the end of the day, if it's not been expressed. And then the best protection you can ever have of any form of intellectual property is executing fast. It's good to have you registered, but sometimes some of your innovation might not be completely registrable, especially maybe if you're going into hardware and it's not patentable, it's not completely new, it's not a substantial difference. The best way you can protect yourself is execute excellently well. So go out there, make your product, market, do all the business things, and be the known provider. A number of people might have the same thing. So if it's not a patentable thing, that means a patent doesn't exist for it. Then your best protection is executing excellently well and being the market leader for whatever it is you're trying to protect. Another thing which I think this is maybe where I might be dovetail to the regulation that SMEs do a lot, is in the application. Now, so depending on which of the IP registration you're doing, they have varying degrees of simplicity and complexity. Copyright is very easy. You don't even need a lawyer to do copyright. Since as far back as, at least I started doing this actively we started doing this actively, 2014, 2015, you can go on the copyright website, create an account. So it's only if you just need help to make it easier that you need a lawyer, but you can actually go on the website, create an account, as long as you have embodied your work in some form of physical, whether it's a script, whether it's a CD, you can submit. You will get your e-certificate on your platform. Then subsequently, you can collect your certificates and then submit that. So for copyright, it's a bit straightforward. But one of the things entrepreneurs find challenging, and which is one of the mistakes they do, for instance, is if you're applying for, let's take patents, for example, like Ms. Enobong explained, there has to be a disclosure. It is very specific how this thing should be provided. Not everyone knows how to do this. It is difficult to be able to state it the way it's supposed to be stated. So if you submit it wrongly, or if you work with someone who doesn't have experience in how to submit the application, your application might not be processed. Trademark as well. So when it comes to trademark, not everything is it has to be unique for you to be trademarked. And then sometimes you find entrepreneurs, maybe trademark is relatively expensive because it has to be in every class. And this is not unique to Nigeria. It's just the way globally trademark is done. You have to register in different classes. So as an entrepreneur, maybe your business is fashion and you've protected your trademark in fashion. And then you see someone who's probably in maybe auto manufacturing using the same thing. Now, an entrepreneur has an expectation. Most of the time, you think that you are also protected there. But so long as you haven't registered your trademark in that class, you actually do not have that protection in that class. Someone else can use the exact same name in that class. So as you begin to expand and as your brand begins to get more visible, it makes sense to even protect your trademark in classes you are not functioning in, so that your brand name is not associated with other goods or undermined in other sectors. It is expensive, but it is what needs to be done as you grow. You can't do that from day one, but as you begin to expand, it's important that you begin to protect yourself in other classes and in other markets that you're likely to enter into. So you see yourself entering into a new jurisdiction. It's territorial. IP generally mostly is territorial. So you see you're going to Ghana in a few months, then it only makes sense for you to protect your assets in Ghana as well, even before you enter, when you start, when there's a likelihood of you going into that market. So as an entrepreneur, you need to be have a bit more foresight, especially if you're able to fundraise. Then I think a substantial amount of your money should actually go into protecting your intellectual property, because it's very relevant to the growth of your business and to your scaling and expansion plans. In terms of registration and interacting with agencies, I think one of the things from my own experience that I think could be a bit easier is making the process a bit more accessible. Like I said, for copyright, anyone can go and get their copyright protected or registered. But for the others, especially trademarks and patents, you need an agent. You need an accredited agent. So you can't go online and submit this by yourself. You need to go through an accredited agent. And then in addition, like for the patent, for example, it would be easier if a lot of the processes were online. It was easy to understand. If there are things like, a bit more transparency, the sample of what an application should look like, so that it's easy for you to prepare your application as an SME in the format that is acceptable. It will be the CSC, for instance, the CSC has evolved to not necessarily using accredited agents. It would be nice if every other agency too took that level of accredited agents out, so that anybody can actually protect their intellectual property by themselves just by going online and submitting this. I think if entrepreneurs had this, you'll find more SMEs registering and protecting their intellectual property and exploiting it for profit and for commercial good for themselves as well.
Thank you very much, Ojo. Thank you. That was very straight to the point. So again, emphasizing what everybody has said, there's difference between idea and developing something that's tangible. Make sure you have all your documentation in place. And then she also provided, and then also even walk through and understand the process on your path to also getting a legal advisor to also help you on that. There are a couple of links that have been shared online on the chat group that we can look through and follow through, even in respect to the conversation. We also had some feedback in terms of how do you improve the process for SMEs? Because SMEs, for instance, one of the reasons why Olumide emphasized get a legal advisor, because SMEs want to do everything themselves. They don't have a chief legal officer, legal person who is situated within the organization and knows that. But on that path to still also getting somebody who will help them from a legal advisory perspective, the importance of making the process, continuing to make the process simpler, easier, straightforward, is also something that we request for the regulators to also look into. Thank you very much. I am going to go to the last round of questions, and those questions will be taking more of the questions that have been sent in the chat box. And I will start with Olumide with 2 questions for you. So first of the question is, how do I protect myself in a partnership? So I'm going into a partnership with someone, probably also sharing my ideas, certain things around my intellectual property. How do I go around protecting myself? So Celestina Otoro had that question. Then there was another question for you in terms of somebody who specifically asked, they have a hardware product and the design of the product internally and externally was done by them, although the product exists in the market, but their functionality, means of production and design is unique. So what they feel is unique is the functionality, means of production, and the design is what differentiates that product from others in the market. Is this eligible for patent, trademark, or copyright? So Lumide, both questions to you. Thank you.
Thank you, Denike. Question number 1 is partnership. The partnership agreement should have clauses that addresses who owns which IP. Now, I believe that this partnership, you're talking about a joint venture where two parties are coming together to develop a product. And usually what you will find is that, if I can go into bit technical, you have something what's called background IP, you have what's called project foreground or project specific IP. And the idea would then be that, look, each person's IP is his asset that is contributing to the partnership. And then, so each one will retain ownership of that IP. And the resultant IP that comes from the combination of the work of the two, which is described as foreground IP or project-specific IP, then will be jointly owned. It depends on the bargaining power. One party can decide to own it and then grant the other party license, or both, but usual starting point will be to say that it will be jointly owned and exploitation will be subject to consent of the partners. But whichever case, your partnership agreement, either partnership, joint venture, collaboration, whatever name you want to call it, should expressly address that. It is a business point, it's a negotiation point. One of the things that I find with people generally, particularly SMEs, is that they feel that lawyers make agreements for them. No, lawyers reduce your agreement into legally enforceable format. You will negotiate the terms of your contract and we will write it out for you. Because we understand the legal, so one of the things that a contract also serves as is it serves also as risk allocation document or means. So we will, if you consult your lawyer, the lawyer will tell you in this kind of business, these are the type of risks that will come up. These are the ways you can mitigate this risk. So that when you then negotiate, you then take that advice on board in allocating responsibilities, allocating risk and duties and rights and remedies. Also, that ultimately, the document is your product that the lawyer will help you draft out. And so you should take ownership of the document to ensure that it reflects what you want and not what the lawyer wants. The lawyer should guide you and teach you. Now, with respect to the fabrication, interesting question. Off the top of my head, I will say patent. But remember that the law says that in order to have patents, it must be. So while for copyright, novelty is not an issue. For patent, novelty is an issue. It must not form part of the state of the art, meaning that the body of knowledge on that issue, what you have done must not form part of the body of knowledge. It may be an improvement or a totally new development. So to the extent that your equipment is not, in quote, that new, it does not qualify for protection for patent. So what would then be the issue? The one that we have not spoken about, because we don't have any law protecting it, trade secret. Number one, the design, the blueprint for that fabrication is covered by copyright. But taking it a step further is to treat it as trade secret. The people who work with you to fabricate it, do you have NDAs with them telling them that they cannot disclose what they have done, or that they cannot work for competition, or a lot of things like that? So that's what. So ultimately, and that's what I've been, and that's why the way I concluded my presentation. IP protection is strategic. There are more than one way to skin a cat. So you need to determine, you need to identify what the work is and the best way to protect it. The best way to protect it may not even be to register it. It may be to just put together NDA, tight NDA that ensures that nobody can disclose, ensure that the information is limited to a few people, or compartmentalize everything. Only few people know how to put everything together. Different people know different aspects and things like that. So we need to start generally, then SME owners need to start being strategic about these things so that they will then know how to they have to take it serious. I was telling someone that, look, as a lawyer, the first time I saw how important IP is to people was when I went to work. I started advising Accenture, and you can't even take laptop out of the office. That's how much they take it serious. Apart from the fact that they've stopped them. How was that English again? Sorry. The floppy disk, the whatever, they've discontinued. You cannot use them. In any case, you can't even carry out the entire laptop. You can't take it out. It's locked up.
Yeah. So they disabled external drives.
Exactly. So Thank you. It's disabled. So that's how serious we need to take our IP and need to plan it. And that is when you can then go into partnership and say, I want to protect my IP. That's when you can say, what are you bringing onto the table? I have valuable IP. I've got know-how. So that's another thing, know-how. And know-how is protected mainly through non-disclosure provisions, vesting of IP in the company. So you are going to be using contracts, employee contracts, contractor contracts, all those contracts need to have IP information that stops them from sharing or exploiting your unique selling product.
Thank you.
Thank you.
Thank you. I'm going to come back to you with a much more practical question as one of the last questions that we'll have. Thank you. Going to the DG, Dr. Mohammed, I hope you're still with us. I want to ask a question now, my follow-on question in terms of how can SMEs find out all this information around how NOTAP is making provisions for local development and innovation. So you talked about a lot of the programs and projects that you're doing, and you gave a lot of examples, even using like CWG as an example. How can SMEs find out about these initiatives that are available, and how can they tap into it? Dr. Mohammed, are you still with us? Okay, I will come back to him shortly. I will go to Enobong and ask a few questions around that have come up around patenting. So we've had two questions. There's one around, can I patent the recipe for a seasoning mix? So I've seen some of our agribusinesses here who have formulations that they've developed, either for cereals or for seasoning and all of that. Can that be patented?
No, it cannot be patented. The best you can do is to keep it as a trade secret, just
Trade
like we have
secret.
trade secrets for Coca-Cola.
So. Yes, thank you very much. And then another question also for you. One of our fashion SME said that she has an idea that has been cultivated into profiling value. How do I know that I'm eligible for copyright? I think that that has actually been addressed because if it's still an idea, then that is actually not, we're not yet at the state that we can have the conversation. And then somebody had also answered the question around the product or service being trademarked. So I'll leave that for now. Dr. Mohammed, I'm going to come back quickly to you. How can SMEs find out about the different products and programs that NOTAP has that they can key into? I don't know if Dr. Mohammed can hear me. His screen is a bit frozen. Okay, you're back now, sir. Where can SMEs find out about the initiatives that NOTAP has for fostering local innovation?
All right, thank you very much. Based on the mandate of NOTAP, we're expected to promote and encourage development of locally generated technologies. Some of the MSCs who have developed technologies and they're using the same technology to produce product and services, we have a responsibility to promote them. And apart from promotion, Our edict doesn't give us a leeway to provide them with some fund. But as an organization, as a government organization, we compile some of these and look for sources of financing for them. I could remember 3-4 years ago, we compiled about 45 flagship projects and now had a meeting with the Bank of Industry to see how they will be able to provide funding. We have met with them. We screened those 45 flagship projects and we reduced them to 6. And I'm happy to say that even though Bank of Industry doesn't seem to have a window to move R&D innovations to the level of products and services, but because of the potentials of SMEs towards the development of a nation, now it's trying to create a window that such kind of flagship projects would benefit. I'm happy to say out of the 6 we have pruned down, 1 had already started accessing funding. That particular innovations that has started accessing funding is like an instant, the product is an instant paint. You know, if you manufacture paint, you transport paint from one location to another, you succeed in transporting a lot of luggage, a lot of water. So, but you have an instant small package where the paint has been formulated in an instant package. So what you are expected is to pour in that instant powder into water, into certain quantity of water, you stir it, already you get your own paint. So it's like another innovation done by Nigerians, and they have started accessing funding. I must say that there is no institutional framework now on ground that provides such kind of windows to SMEs. But I'm sure Smes, Bank of Industry are also trying to. So anyone that has, and we are fully sure that it is functional, we can use our office and formally introduce them to these respectable institutions that would help them. Thank you very much.
Thank you very much, sir. Thank you very much. Yes. So my last question will be for Linda in terms of copyright. Somebody is asking if an architectural design can be registered with copyright. I think you addressed that too.
Hello?
Yes. Architectural design can be registered with copyright.
Works of architecture can be registered with copyright in terms of building models.
Okay.
When the architectural work has to do with building models, it can be registered with the copyright.
Thank you. Thank you very much. So thank you once again to our panelists. I'm going to do a last round for you to just give your closing remarks. And please touch on any important or particular areas that you think we may not have mentioned, but you think it's important to emphasize in 40 seconds, please. Again, as we round up these conversations on IPs and SMEs, what is a last word that you want to give to SMEs to take note of in the context of this conversation? I will start with you, Dr. Mohammed, over to you.
Well, thank you very much. My major concern is to see Nigerian research and development becoming very vibrant, so that we begin to see technologies coming out from this research and development endeavors. And these technologies should be fully protected. And individual companies would be encouraged to take up some of those technologies developed by Nigerians. We should not continue to rely on foreign technologies. That does not help the development of our nation. We should not be under any illusion somebody would develop our own country. No, somebody from somewhere outside the country will come and develop our own country. The responsibility of the development of our nation securely rests on us Nigerians. So we need to synergize to ensure that we work closely. You play your part, I play my part. Everybody plays his part so that collectively we move our nation forward. Thank you very much.
Thank you very much, sir. Thank you. And over to you, please. A final word.
Okay, I'd like to tell SMEs that while it is not mandatory that you should protect your invention or get a patent over your invention, it is really, really important because even when you keep your invention as a trade secret, there's always room for reverse engineering. And under the patent system, it's a first-to-file system. So it's the first person that comes to file that the law recognizes. We have the statutory inventor and we have the real inventor, but the law recognizes the statutory inventor. The statutory inventor is the person, whether or not he's a true inventor, is the first person to come to law for protection. So I would like to encourage our SMEs, if you have an invention and you know it's really a product of your idea, please come forward and register it and get a patent over it, because in law, ignorance.
Thank you very much. Thank you so much, Eno, for emphasizing that. The first person is recognized. The first person to make the registration notification is recognized. Linda, please, your roundup closing point.
Hello. My
Yes, we can hear
last
you.
remark I would like to say to SMEs, they should please identify the copyright works embedded in their creations. Copyright works that they have created, they should identify it, exploit it, manage it, and protect it, because copyright is inevitable in their businesses. I have mentioned some of them that will certainly occur as they do their businesses. These things eventually, though they are intangible rights, but they eventually turn out to be the main capital of the company. They can use it in so many ways. They can use it for licensing, even to get bank loans. It ultimately helps in increasing the value of the company. So please, SMEs, take care of your copyright, manage it well, and you will enjoy it. Thank you.
Thank you. I think that an important action point, which you've emphasized, is that let's go. I know a number of us are redoing or updating our business plans or our business strategies. And a very key activity point is definitely for us to be able to identify what our different IP right opportunities are across all our business lines, our products, our services, at whatever stage we're in. So even if it's an idea stage, is even looking forward to say, okay, what are the potentials for IP that that can evolve for my business as I'm building it, or if I'm an established business, what are the different what is the audit? How do I do an IP audit and identify the different IP potentials? Thank you. And Odun, over to you, please.
Thank you. So I'm just going to answer 2 quick questions I saw and make a comment. One was the duration for copyright. It ranges. So generally it's between 50 to 70 years. For some works, it is from when the person created it. For some, it is from the death of the author. But there is a time duration for copyright as well, and it's 50 to 70 years. There's another question that asks whether the CAC and trademarks were harmonized. No, we don't have a harmonized registry in Nigeria. So if you protect at the trademarks registry, you still need to at least register it as a business name, even if it's not a limited liability company, to protect that name. And the last thing I would like to mention as an advice is when you're an SME and you're employing people, you need to make sure that your employees sign something called a confidentiality, innovation, and intellectual property assignment agreement, a CIPA. Basically, so that whatever that they work on, they are assigning it to the company, to the business, because if there is no assignment to the company, then it belongs to the creator of the work, who is the employee.
Thank you very much, Odun, for that, and also answering some of our last questions that just came up. Thank you. And Olumide, over to you. You started the conversation. Now, please, I'm going to ask you to formally give your closing comments on this. Thank you. You're on mute, please.
I fell into that finally. Yeah? All right, so number one is to thank everybody for coming and for participating in their time. And number two, to just remind our listeners that, so essentially recall, if you would not remember anything, remember 4 things that, or I would make it 5, but let me say 4 things under which I made my presentation. One is understanding the importance of your IP. 4 steps you need to take. 1, you need to identify IP. 2, you need to secure your IP. 3, you need to protect your IP. And 4, you can then exploit it. If you have not identified it, you will not know what to secure and you will not know what to protect. And it is what you have secured and protected that you can exploit. IP becomes, the value of your IP becomes enhanced in view of the exclusivity that you have. And that exclusivity comes from having secured and protected it. And that then opens the door for exploitation. A good example would be Virgin, Richard Branson. He has up to like 15 companies in the Virgin Group, and it's not all of them that he owns. There are some that all they enjoy is a license. He licensed the Virgin name to them. That's an innovative way of using your IP. So it's a form of assets that can create financial gain if properly used. And forgive me, but it will be remiss of me if I don't say this last one: get a lawyer. I heard what Odo said about doing it yourself for most entrepreneurs, but you will need, unless you are an educated or enlightened or a trained entrepreneur, you will need guidance from people who know these things. IP law is a specialized area of law that requires, which will require guidance one way or the other. So get the lawyer who knows his way around, who has experience, who can guide you. The people remember this saying that if you say education is expensive, try the cost of ignorance. It's applicable here too. If you say the lawyer is expensive, when the infringement comes, you will realize that what you ought to have invested in a lawyer, you are going to lose it almost double or triple that. It's always important to have your lawyer as your close friend and business associate. So we thank WIPO for giving us the opportunity to do this. We hope discussion will continue after this, but thank you everyone for coming.
Thank you for rounding up. The lawyer is your friend. Get a lawyer as soon as you can. You just never know. And I can say that for a fact, even as a non-profit organization, the importance our lawyers have been to us. And so thank you so much to all our panelists. I've been requested to have all our videos turned on so we can quickly do a screenshot, please. This is the last request I have of you. I know we're 6 minutes over time. So please, can the DG, can Odu, can Linda, can Eno please quickly turn on their video cameras on? Just last a few seconds, please. Odu, Eno, the DG. The link, a few of us have asked for the link to the live streaming. So this has been recorded and is being live streamed on YouTube. The link is being posted and we'll resend it to everybody that has registered. So, okay, I think all our panelists have had to go to other conversations. So Cindy, if you can just quickly do a brief, we'll do a mashup of, thank you very much. Thank you. DG, please, maybe we'll have to Photoshop DG's on from previous conversations in this shot. So 1, 2, 3, cheese.
Cheese.
Thank you very much. Thank you so much once again to our special guest. I now hand over to Chinasa to formally round up. Thank you very much.
Thank you everybody who's been a part of today's event. At the beginning of this program, we wanted to achieve certain things, which is to explain what intellectual property is and why entrepreneurs need to understand it and use their IP to grow their businesses. Wanted to understand the different types of IP, copyright, patent, implications for businesses, and get clarity on the perception that only hardware and software technology businesses should be interested in IP. I believe that our speakers have done justice to that. And so at this point, I would just like to thank everyone who has contributed to the success of today's discussion. Thank you to all the participants, without whom this program would have been unnecessary. I would also like to say a big thank you to all our speakers. Adenike has already done so. Thank you for sharing from your wealth of experience and knowledge. And then in particular, I would like to thank those people who worked behind the scenes in Banwa Nigodalo and Faith Foundation to ensure that this program is successful. So from Banwa Nigodalo, I would like to thank especially Temilola Ibidapo Obe, Associate in BNI, and for Lauren Shaw of FS2, the social media manager and graphic artist. I'd like to thank from Faith Foundation, Cindy Ipe, community manager, Orange Corners, Nigeria at Faith Foundation, and Great Okazim, program officer, startups and youth enterprise at Faith Foundation. And so everyone, we're celebrating the World IP Day. Happy World Intellectual Property Day 2021. Bye-bye.
Thank you, everyone, and have a good day. Thank you so much. Thank you to Bawa and Godalo for the opportunity. And thank you to the Faith Foundation team and the Faith Foundation entrepreneurs who joined in different ways. We appreciate you. And the non-Faith Foundation entrepreneurs too. We will send an email again with the link. The link has been shared. The recording will be shared. And with Mr. Osujolire's permission, we'll share the slides that he earlier presented on, and we'll circulate it to. You don't give us the permission. You know, we have to be asking about copyright permission now. This is your intellectual property.
No problem. Please feel free to share.
So we'll share that. We'll share that with everyone. Thank you, everyone. Happy World Intellectual Property Day.